If you're going through a custody split or trying to manage an existing child support order, I want you to take a deep breath. I know exactly how overwhelming this math can feel. When I was a little girl growing up here in Wilmington, long before I went off to ECU or law school in Boston, I used to draft literal contracts for my family members. I would write out strict clauses detailing who was responsible for walking the dogs and what the penalty was for skipped chores. I guess you could say I've always looked at the world through the lens of structure and rules. But I'm also a child of divorce. I know firsthand that underneath all the court paperwork, there are real human lives, real stresses, and a lot of anxiety about making ends meet. One of the biggest drivers of consultations here at Kate for Family Law is simple. It's confusion over when child support orders can actually be changed. In North Carolina, you can't just request a modification because life feels a little more expensive this month. Under General Statute 50-13.7, you must prove a substantial change in circumstances. But our legislator created a built-in shortcut that most parents don't know about. If your current child support order was entered at least 3 years ago, and you run a brand new calculation using the official North Carolina child support guidelines that results in a difference of 15% or more, either higher or lower, the law automatically presumes a substantial change has occurred. You don't have to prove anything else. That 15% gap is your golden ticket to legal review. So how do we find out if there's a 15% difference? It all comes down to the North Carolina guideline worksheets. This isn't an arbitrary number a judge just pulls out of thin air. It's a rigid calculation based on gross monthly incomes, health insurance premiums, and work-related childcare costs. The most critical piece of the puzzle is choosing the right worksheet based on your custody schedule. Worksheet A is for primary custody. It's used when one parent has the children for 243 or more overnights out of the calendar year. In this scenario, the non-custodial parent pays a flat, higher percentage because the law assumes the primary household bears the bulk of the daily expenses. Worksheet B is for shared custody. This kicks in the exact moment the second parent hits 123 nights or more per calendar year. Once you cross that 123-night threshold, the math shifts dynamically, accounting for the fact that both households are maintaining full-time living expenses, groceries, and utilities for children. What if your order isn't 3 years old yet, but you still need a modification? You can still file, but you have to prove a real involuntary shift in your life. A regular text message saying, "I lost my job," is not going to cut it. A judge is going to look for a few distinct structural changes. Involuntary income loss, a corporate layoff, a medical condition preventing you from working, or a structural company downsize would qualify. But if you quit your job voluntarily to avoid support, the court will simply impute your old income and leave the order exactly as it is. Shifting child needs, a child developing an ongoing medical need requiring expensive treatment, or conversely, a child aging out of costly daycare, dropping your monthly expenses by hundreds of dollars. And then actual custody shifts. If your court order says you have worksheet A, primary custody, but your teenager has been living full-time with the other parent for the last 6 months, the financial reality must be legally updated to match the physical realities. If you want to pursue a modification and get a predictable outcome, you need to treat it like a business audit. Do not guess your numbers. Gather these 4 items immediately. 1. Pay stubs and W-2s, your last 3 to 6 months of your consecutive pay stubs. If you're self-employed, you will need clean profit and loss statements and tax filings. 2. The true cost of health insurance. Print the explicit corporate rate sheet showing exactly what portion of your monthly premium goes to just the children's coverage, not yourself or your spouse. 3. Verifiable daycare invoices. Receipts or tax statements proving exactly what you pay for work-related childcare, not Venmo and Cash Apps. 4. A verified calendar, a rock-solid log of the exact nights the children slept under your roof over the last year. Child support isn't a weapon to punish an ex, and it shouldn't be a financial prison for either parent. It is meant to provide a steady, realistic safety net for your kids. If your life has changed significantly, don't let a bad worksheet calculation break your monthly budget or leave money on the table that your kids are entitled to receive. Let's sit down, run the actual math together, and establish clean, realistic expectations for your next steps. If you need a review, challenge, or modify a child support order in North Carolina, let our team run the numbers accurately. Kate for Family Law, Wilmington, Durham, and Jacksonville. Link below to book a confidential consultation.